All right. Good morning, everyone. My name is Mike Hecker, and I'm a partner at the law firm of Hodgson Russ and a member of the board of directors of the Law Alumni Association. And on behalf of the Law Alumni Association and its standing committee, the Graduates of the Last Decade, or Gold Group, I'd like to take a moment to thank you for attending today's webinar on the Payroll Protection Program. This is one of a series of webinars, including 1 hour of free CLE credit that the Law Alumni Association is providing to alumni in the wake of the COVID-19 pandemic. If you find this to be interesting, and if you're curious about the other benefits that the Law Alumni Association offers to members, we'd encourage you to go to the law school website, which has a link to alumni, and check out the membership benefits and consider joining us. Our next program is going to be offered on May 28th. It's going to be presented by Brian Detweiler, who's a law librarian at the law school. He's going to be talking about free and low cost research tools available to alumni through the law school. In addition, on June 12th, there will be a presentation about employment and family law-based immigration considerations in the wake of the COVID-19 pandemic. That can be registered via the law school website on the CLE programming tab. Today's program is underwritten by the Gold Group sponsors, and I'd like to take a moment to thank them. AXA Advisors, Chicago Title, Council Press, Fine Law, Jack W. Hunt and Associates, and Precision Resolution LLC and Paramount Settlement Planning LLC. So thank you all. A few brief administrative points before we begin. First, all attendees will be on mute during the course of the presentation. There will be a question and answer time at the very end. If you have any questions that arise during the course of the presentation, please enter them into the chat box. I will be moderating those, and at the end of the session, I will be presenting those to the presenters. In addition, for those of you seeking CLE credit, there is an attorney verification form that needs to be filled out, which can be linked to via the registration link you got from this email, as well as on the registration link on the law school website. There will be a participant code that's going to be announced during the course of the presentation, and it will also be included in the chat box. Please be sure to follow along for that and enter it into the form. There's also a program evaluation form via the website that we'd appreciate if you consider entering. So with that, I'd like to introduce our two speakers. The first is John Godwin, who's a 2007 graduate of the law school. He's a partner in the labor and employment group of the law firm of Hodgson Russ. He focuses his practice on management side labor and employment matters and has specific expertise in wage and hour compliance, general employee benefit and management issues, as well as other considerations. Cheryl Jankowski is a certified public accountant, and she is a partner at the accounting firm of Lumsden and McCormick LLP, and has extensive experience working with business owners and individuals on minimizing taxes with a focus on succession planning. So with that, I'll turn it over to our speakers.
Thanks, Mike. As Mike said, I'm John Godwin, partner in the Labor and Employment Group at Hodgson Russ. And on behalf of myself and Cheryl Jankowski, we're happy you were able to join us this morning for our program on the Payroll Protection Program. This is probably one of the most prominent, if not the most prominent programs that we've seen come out of Washington. It's certainly been a program that is, by this point, near and dear to my heart, as I've spent the last several weeks living with the ups and downs and the twists and turns of this thing. And it's been fascinating, both fascinating and frustrating. But we've got a good program here for you today to try to lay out the nuts and bolts of this thing and where things sit as of today. But before we get there, why don't we just understand where we've been? Kind of a brief history here of the last few months. March 13th, of course, the COVID emergency declaration is issued by the federal government. Within 14 days of that, the Coronavirus Aid, Relief, and Economic Security Act, the CARES Act legislation, was passed by both houses of Congress and signed by President Trump. Very quick response to the emergency declaration. Within a few days, we had SBA issuing its first interim, what would turn out to be the first of many interim final rules that clarified some questions that practitioners had at the time, as well as changed certain key elements of the PPP loan program under the CARES Act. And then on April 6th, most local lending institutions began accepting PPP loan applications. There was April 6th was a Monday. Some banks had actually started maybe late the Friday before or over the weekend. And combined with the guidance, which said this was first come, first serve, this resulted in a very hectic weekend for a lot of borrowers that were trying to get in line to get the PPP funds. On April 14th, we had SBA issue the interim final rule for PPP loans for sole proprietors and independent contractors. So there's kind of two branches of the program. This was the second branch that SBA covered. And then on April 24th, Congress approved an additional $484 billion relief package that extended the Payroll Protection Program and Healthcare Enhancement Act. Through May 6th, Department of Treasury and SBA have issued FAQs. I checked them this morning, as I do dutifully every day. We're now up to 48 FAQs. If you read them through, you'll get a sense of how the answers have flipped and then flopped in some important areas of this program. And then just recently, as Cheryl and I were preparing for this program, we were talking about the forgiveness guidance that was supposed to be forthcoming for the last several weeks. We did get that in the form of a draft forgiveness application and set of instructions that was issued on May 15th, so just a few days ago. And that answered many questions that borrowers and practitioners have, but it left a number of them unanswered. And then what we've seen now in the last few days is some mixed messaging as to whether additional or further guidance on forgiveness will be forthcoming. Many practitioners were expecting not just an application with instructions, but an interim final rule that addressed how this was going to work. I saw that Secretary Mnuchin was testifying before Congress to the effect that he thought the application and the instructions had answered, quote, all of the open questions. We beg to differ, but that indicates that perhaps Treasury and SBA may not be issuing an interim final rule or additional guidance on forgiveness. We'll have to stay tuned. So what is the Paycheck Protection Program? Combined with the second tranche of funding, it is a $659 billion expansion of SBA 7A business loan program. The 7A business loan program of the SBA is its bread and butter business loan program to businesses that have been impacted by natural disasters. So this was added on to the 7A authority. The initial $349 billion tranche was boosted on April 24th by an additional $310 billion tranche to bring the program to its total of $659 billion. There still remains funds available for borrowers that are looking at this. This has surprised a lot of folks. That the second tranche has not run dry yet, but at least as of the most recently publicized guidance we've seen, there still remains funding available. The PPP liberalized eligibility for and the requirements of a 7A program. For instance, there was no collateral that needed to be pledged, no personal guarantees that needed to be provided, and the Congress, in passing the PPP, suspended the requirement, I should say, that borrowers not be able to find credit elsewhere, the no credit elsewhere test, which is important. CARES Act also set forth, and this is the hallmark provision of it, this is what gets the most attention, the possibility of loan forgiveness under certain circumstances. So the idea that this could be effectively what I've heard referred to as a grant or free money rather than a low interest loan is what has enticed many companies and businesses to look carefully at this program. Guidance continues to be issued by Treasury and SBA almost on a day-by-day basis, sometimes more frequently than that, and the program continues to evolve at a very, very rapid pace. Couple of important observations about SBA 7A programs. Okay, they are not loans directly from the federal government. 7A programs are administered by private banks. The federal government guarantees the loans that are made by eligible lenders to eligible borrowers. Small business concerns are eligible to participate. Small business concern is a defined term in the SBA world. There's both statute and regulations that define that, and Congress quibbed it for this PPP legislation. It's tied to earnings and industry-specific employee counts that is based on your client's NAICS code, which is its industry classification code. Importantly, however, Congress passed the PPP and in doing so expanded the general 7A eligibility beyond just small business concerns. So it also captured other businesses and certain not-for-profits, 501c3s generally only, with no more than 500 employees. Okay, so that was a liberalization of the requirement. No not-for-profits are eligible for 7A programs generally. Congress said with the PPP, 501c3s with less than 500 are in. Interestingly, Congress also allowed the 500 employee cap to be exceeded for just certain industries based on NAICS code. And the number of employees is considered on an affiliated company basis, such that all businesses under common control would count the employees in the aggregate. So the 500 employee threshold is not just done looking at one affiliate, one subsidiary, or one company in a broader kind of affiliated company relationship. You need to look at all quote unquote affiliates. And the SBA has very specific guidance on how they apply the affiliation rules. We've also just recently got guidance that SBA is going to count the foreign employees of affiliated entities as well in determining whether you hit this 500 employee cap. As I said, for certain NAICS code, the affiliation rule is waived. And that the NAICS codes that those cover 72, which cover hospitalities and restaurant businesses, so hotels and restaurants and bars, they do not have to comply with the 500 employee cap on an affiliated basis. Franchises also do not have to cover or comply with the 500 employee cap. That's a significant point to bear in mind. And then also recipients of small business investment company investments. Those are the only three types of entities that are accepted from this 500 employee cap on an affiliated basis. The guidance that the SBA issued also confirmed that a business concern could qualify for the PPP if it met what the SBA refers to as its quote alternate size standard. If you read the PPP, you would not appreciate this. This is something that they've done on a regulatory basis, and this alternate size standard is something that the SBA applies in its ordinary 7A context, and it saw fit to extend it to the PPP. This subsequent guidance states that a business can qualify for the PPP if it meets both parts of the SBA's alternative size standard test as of March 27th of this year. And those two requirements are that they have a maximum tangible net worth of the business of not more than $15 million and the average net income after federal employment taxes, excluding any carryover losses from prior years of the business for the 2 full fiscal years before the date of the application, is not more than $5 million. So if a business satisfies this alternative size standard and has over 500 employees, it would still be eligible for the PPP. So for practitioners, this is something to be aware of when you're dealing with companies that you're concerned are too big from a headcount perspective. Borrowers must make a good faith certification when applying for a PPP loan. There are actually a number of certifications that need to be made, but the big one that has captured a lot of attention is that which we have here at the top of the slide. And that's that the current economic uncertainty makes the loan request necessary to support ongoing operations of the applicant. You also need to acknowledge that the loan will be used to retain workers and pay eligible expenses, and that you do not have an application pending for a loan for the same purpose, or that you have received any other loan for the same purpose between December 30 or through December 31st, 2020. This certification, when it came out, in March, and practitioners were looking at it, given the situation that many businesses found themselves in, which was a state of, frankly, complete uncertainty about the future, about how long these shutdowns would last, about what the trajectory of this pandemic was going to look like. A lot of businesses that were suffering economic hardship, furloughing employees, reducing pay, having a significant drop in their business, those folks felt pretty comfortable making a good faith certification that current economic uncertainty makes the loan request necessary to support their ongoing business operations. Well, it turns out that the economic situation wasn't the only one that was uncertain. The SBA and the Treasury, responding to news media reports about larger companies that were receiving PPP loans, some of which were publicly traded, Shake Shack and the like, issued this FAQ number 31 on April 23rd. And this was seen as a direct response to companies that were, quote unquote, not seen as worthy of these PPP loans. And what this provides is, it says that borrowers must make this certification in good faith, taking into account their current business activity and their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that is not significantly detrimental to the business. Well, that landed like a bomb. For a lot of borrowers, okay, they had been taking into account their current business activity in applying for these loans. But when Congress passed the PPP, as I had said earlier, they suspended the requirement that the business be able to demonstrate it could not obtain credit elsewhere. So now what you see with the Treasury and SBA doing here is they're reinserting this concept of having access to other sources of liquidity sufficient to support ongoing operations. So it moved the needle from where many folks thought this program had been, focusing kind of on business and economic uncertainty, to one that was now also looking at what other sources of liquidity you had. And that raised a whole host of very fact-specific problems. Some clients had some cash on hand, cash reserves. Other clients had lines of credit with banks. Some of those were not guaranteed lines. They were non-guaranteed. Other businesses potentially had the ability to try to raise capital from their shareholders or in other sources. And, you had to be able to show that that was either not sufficient to support ongoing operations or that it was significantly detrimental. Phrases that SBA and Treasury did nothing to illuminate. This created a ton of uncertainty. And what you had Treasury saying here was that if any borrower that applied for a PPP loan prior to April 23rd, if they repaid the loan in full by May 7th, they're deemed to have made the certification in good faith. And, you know, there was some saber rattling about fraud and criminal charges if the certification was made not in good faith. A few days later, a couple weeks later, on May 5th, SBA extended the safe harbor repayment date through May 14th from May 7th and stated that we'd be receiving additional guidance before that deadline. They met their promise, but just barely. On May 13th, they released FAQ 46, which calmed the waters for many borrowers. It created a safe harbor which said that any borrower that, together with its affiliates, received PPP loans with an original principal amount of less than $2 million will be deemed to have made the required certification concerning necessity of the loan in good faith. So if your loan amount, together with affiliates, is total loan amount is less than $2 million, you're deemed to have made this certification in good faith. If you're north or $2 million north, you're in the soup, so to speak, where SBA's requirement here that you have to had considered other sources of liquidity and whether accessing those other sources would be significantly detrimental are things that you have to consider. And for a lot of businesses that were already midstream in the program, this presented a whole host of practical difficulties. You know, for instance, they had done things that they would not have otherwise done because of the loan. They had retained employees, which was the intent. They had maintained their payroll. They had not taken steps to reduce payroll expenses. And, you know, now if this loan is suddenly not going to be forgiven or something worse, that would put these employers in a really, really difficult position. The other thing that kind of dovetails with this is that Treasury and SBA in an FAQ released on April 29th, they both took the position that they will quote unquote review all loans in excess of $2 million and other loans as appropriate. So it looks like everybody who has a loan in excess of $2 million is going to get an automatic audit of their forgiveness application at that time. And the FAQ states that the intent here is to further ensure PPP loans are limited to eligible borrowers in need. And they've promised additional guidance to be forthcoming. You know, I think the practical takeaway of this is if you're going to be a savvy borrower, you should get your documentation in order, especially if you're above the $2 million threshold. Contemporaneous documentation of the business circumstances, the business activity, the uncertainty created by the pandemic and the resulting economic carnage, and then also your other sources of liquidity. Either, you know, identifying why you do not have other sources of liquidity, or if you do, why those other sources are not sufficient to support your ongoing operations without you know, significantly being detrimental to the business. Having that documentation in order, getting that together and having that ready so that when you do have to sit down with the auditor from SBA or Treasury, you're able to justify you made the certification in good faith. I think that's the best you can do in this circumstance to ensure that your borrower is prepared for what is inevitably going to be a review that is probably informed in part by after the fact circumstances. So with that, I will turn it over to my partner here, Cheryl, to talk about the maximum loan amount.
Thanks, John. So I'm Cheryl Jankowski. I'm a tax partner with Lumsden and McCormick. And, you know, this is the nuts and bolts, and I'm hoping not to get too much into the weeds today. What's interesting, and I think John could also chime in, that, you know, this is the guidance that was, a lot of this that we'll talk about in this part of the presentation is guidance that, additional guidance we received literally a week ago. And as part of the next potential congressional act called the HEROES Act, there could be some additional changes to this PPP program, and they've got a separate bill that has bipartisan support. So I really want to emphasize bipartisan support because it doesn't necessarily happen too much in Washington. And some of the things we're going to talk about today may change significantly in a week. But this part here, any of the potential guidance, I think is going to be more on the loan forgiveness side. But let's look at what some of the maximum loan amounts. So as John mentioned, at the end of March, we received this CARES and the PPP program was part of that. And we shared with clients that the PPP program was really geared for employers to retain their employees, to try to prevent massive unemployment claims. And so that really the employer in some instances was kind of the unemployment office. And like John said before, employers did make decisions to retain employees, whereas maybe they would have laid those individuals off if it wasn't for this program. So the PPP, the maximum amount of the loan, was a lesser of 2.5 times the borrower's average monthly payroll cost, which we'll talk about in a second, over the previous 12-month period. And when we were doing these applications, sometimes we looked at a period of 2019, or you could have looked at from March 1st, 2019 through February 29th, 2020 for your 12-month period. And then you compare that to the $10 million. So it was the lesser of the two amounts, maxed at $10 million. Now the formulas varied slightly for seasonal and new businesses as well. And seasonal employers are still a challenge in trying to compute some of the head counts and such, which we'll talk about shortly. So what could be included in payroll costs? Well, I'm going to emphasize what wasn't included. It wasn't the employer's share of any payroll taxes, the Social Security and the Medicare taxes. So that got excluded from the payroll cost. So it was the wages, healthcare benefits, retirement benefits, but not for owners. As I mentioned, healthcare benefits. And there was a question with regard to whether sole proprietors, since they didn't receive wages, how would they compute what their payroll costs were, because potentially they weren't running a payroll. So we received some additional guidance that you would look at their Schedule C income to determine what their, essentially what their wages were. Afterwards, we did, a little bit later, there was additional guidance that was presented with regard to partners and partnerships. Those partners don't receive wages. And so the question was, can they be considered part of the payroll costs for the PPP loan application? And additional guidance recently came out that said, if you did not include those partners in your payroll computation, you can now add them and have a second application for those additional costs. So generally speaking, it was one application for the PPP loan for these payroll costs and some other costs that we'll talk about shortly. But you can go back if you are a partnership if you didn't include the partners. Now, payroll costs did have a cap to it. So if you had highly compensated individuals, anybody's payroll in excess of $100,000 was not included in that computation. So if you had an employee named John Smith and he made $150,000 for 2019, and you were looking back at that as your payroll period, you had a cap amount at $100,000. In addition, if you're paying individuals that do not reside in the United States, they could not be included in the application. And there was, under the Family First Coronavirus Response Act, there was some additional credits available under qualified sick and family leave. So if you were tapping into those benefits, those payroll amounts should not have been included in your payroll costs for the maximum loan amount. John, if you want to advance. Now, additional guidance was received that the entire amount that essentially in a single group, or like an affiliated group, could receive is $20 million of loans. And so that is part of that loan forgiveness application, is that you're going to mark that your loan as part of an affiliate did not exceed $20 million. The loan forgiveness form is Form 3508. It's an SBA, Small Business Association form that you would complete, and the instructions and the form itself with some worksheets are included in that Form 3508. We're going to just take a second here for your continuing education verification. Word of the day is the word loans. And Mike, if we're set to go, just nod your head. All right, great. So what were some of the permitted uses of the PPP loans? As part of that application for the loan forgiveness, you were able to add the payroll costs that we just talked about, rent, and let's just talk about rent for a second. When I first read rent, I was thinking about your office leases, that you would be able to cover that rent. In addition, think about other types of rent that you may pay. And I think of copier leases. A lot of times offices, they don't buy their copiers outright, they may rent them. So think about anything else that you have with a written lease agreement that can be included in this rent bucket. Utilities, such things as your, your electric, gas, internet, but all of these, whether it's the rent, the utility, or the interest payments, had to be things that were in place as of February 15th, 2020. So now with people working remotely, maybe you have some additional costs that you're covering for employees. If those were not being covered as of February 15th, those should not have been part of your loan application, and that will not be part of your loan application for forgiveness either. Now, one of the key things that we had recommended to clients with regard to the loan proceeds is that, as John indicated, we have to really be able to trace where those costs went. So if we received a $2 million PPP loan, we recommended to clients to put that into a separate bank account. And that way it might be easier for that business to track those expenses that were paid for payroll, rents, utility, and interest payments. And because at the back end of this entire process, you're going to have to submit verification of all of those costs that you paid from the PPP loans. So that was one of the thoughts that we had. The other interesting thing that came out of the loan forgiveness application was, we weren't quite sure if it was all costs paid during the 8-week period after you received the loan. That's what's called the covered period. So from the date that you receive the loan for the next 8 weeks, those are the costs that are eligible for loan forgiveness. And the loan forgiveness application clarified that it's expenses paid and expenses incurred during that period of time. So for example, if you had a payroll that's, you received your loan on April 20th and you paid for a payroll as of April 22nd, those were payroll costs paid during your covered period, that 8-week period of time. Now, what was interesting was folks were concerned that that 8-week period may have included partial payroll periods, and whether they were going to have to run a special payroll to have those costs paid within the 8 weeks. Well, because of the incurred language in the loan forgiveness application, even if you pay a payroll after your 8-week period, you can take those costs that were incurred during your 8-week period as part of the loan forgiveness application. In addition, only for payroll costs, they established an alternative payroll covered period. What does that mean? So for employers that have payroll periods that are biweekly or more frequent, they can essentially align those payroll periods and not have to take partial periods. So for example, if we received our payroll protection loan on April 20th, and yet our next payroll period started April 26th, we could elect, and this is at the election of the borrower, to start our 8 weeks during this alternative payroll period from April 26th and run it 8 weeks out. So it doesn't have to necessarily align with the 8-week period of the covered period. However, the covered period that 8-week period does apply for interest, rent, and utilities. So you could have a borrower that has 2 different covered periods. They may have chosen the alternative period, payroll covered period, and then also be using the covered period for the other types of payroll costs. Now, one thing that I thought was interesting about the paid and incurred language is when we think about payroll costs, because we want to make sure that we can maximize our loan forgiveness, is that we can also take a look at expenses that we can pay during our 8-week period. And so one of the questions that has come up is whether if you had an employer as the borrower, you have a 401k match that you would have funded by March 15th, 2020, but you extended that time and you pay it during your 8-week period of time, your covered period. It appears that those, because you paid that during the 8-week period, that those would be included in your loan forgiveness application. So it'll be interesting to see, because those are costs that were actually incurred in 2019, if there will be some additional guidance in that area. In addition to the paid and incurred, I wanted to mention that for utilities and such, as long as you are continuing to pay your utilities on a timely basis, you may be able to pay for utility costs or other types of costs outside of your 8-week covered period. But because those expenses were incurred during your covered period, they would be eligible for the loan forgiveness. So it's pretty complicated, and it's going to be very important to make sure that we gather all of our data to make sure that your loan forgiveness can be maximized. Now, the loan forgiveness can be reduced, and this is what we've been working very closely with our clients with right now, is to make sure that we understand the calculations to make sure that we can maximize the loan forgiveness. So when we first received the guidance, and we were looking at full-time equivalents, part of the program was geared to employers to retain their full-time equivalents. And if they didn't retain their full-time equivalents during the 8-week covered period or alternative payroll covered period, they may need to reduce the amount of their loan forgiveness. And they would compare their full-time equivalent to one of 3 periods. The period from February 15th, 2019 through the end of June 2019, or you could have looked at the first 2 months of 2020. And then we received some additional guidance that for seasonal employers, you could look at the 12-week period of the average full-time equivalent from May 1st through September 15th, 2019. Now, when we first were discussing full-time equivalents, the thought was that it was going to be based, full-time equivalent was going to be based on 30 hours. The loan forgiveness application makes it clear that a full-time equivalent is considered 40 hours. So that's one of the biggest changes that we saw and may affect the calculations. In addition to full-time equivalents, many employers have folks that work less than 40 hours a week. And how do you compute the full-time equivalent? Well, they've given folks or borrowers a couple different options to take a look at. If, say, you had an employee that worked 30 hours a week, they work basically 75% of a full-time equivalent. In that calculation, the SBA, the guidance provided, says that you can either round that 0.75 up to 0.8 or treat anybody that works less than 40 hours a week as 0.5. And that is a simplification, and that is at the option of the borrower. Our goal is to make sure that whatever base period we're choosing, we're going to try to have the lowest full-time equivalent headcount during that period of time. The reason for that is we compare the full-time equivalents, the average full-time equivalents during our 8-week covered period compared to our base period. And we want that number to be 1, because if it's less than 1, we have the potential of a loan forgiveness reduction. In addition, there was, right after the COVID hit, sometimes folks were taking salary reductions to preserve cash flow for the business. Well, if you've reduced the salary, and you have to look at it on an employee by employee basis, in excess of 25%, you can also potentially have another reduction as well. One of the things that with planning, especially a lot of our clients are within this 8-week period, we're trying to understand if there was salary reductions and whether we should restore those salaries before our 8-week period runs out. And we're also trying to understand where we are in that full-time equivalent quotient. So those are two very important things to be looking at. And I think it's important to be trying to be proactive about this instead of trying to, and there is a cure, potential cure for employers, trying to cure it on the back end. So when we look at preliminary forgiveness, we look at our total payroll costs. So those are our wages, health insurance, retirement, certain unemployment insurance, plus our non-payroll taxes, non-payroll costs such as rents and utilities and interest. And then we subtract off any applicable wage and salary reductions. So those were employees, not owners. Owners have their own separate bucket and are not included in this part of that calculation of salary reduction. And we might have to take a subtraction if we reduce salaries. And then we multiply that by our full-time equivalent quotient, which is our average full-time equivalents during our covered period divided by whatever we chose for our base period. So a quick example might help bring this, and I know it sounds like a lot of information, and it is a lot. So for example, if we had a $4 million loan and we spent $2 million on payroll and $2 million on non-payroll costs. Now remember, at the loan application, you were supposed to spend 75%. The goal was to spend 75% of a loan on payroll costs to achieve full forgiveness. Well, in this example, since 50% of the loan was spent on non-payroll costs, we gross up the $2 million payroll costs, we divide it by 0.75, and this employer would receive loan forgiveness of $2.6 million because they spent essentially $1.3 million on non-forgivable costs because they didn't spend enough on payroll here. Now there is some cures out there, and this was, I think, what we were kind of hoping for, because it's been very difficult for employers without good guidance to, you know, they might have reduced payroll, they weren't sure if they were gonna receive the loan, then they received the loan and they're trying to bring folks back. So there's a couple potential cures that we can do to help reduce any, to avoid any loss of the loan forgiveness. And one is the wage reduction. So if we reduce wages between February 15th and April 26th, and that was a very real thing for a lot of borrowers because, you know, as of mid-February, you didn't know that there was going to be the CARES Act that came in at the end of March, and then we had the application and approval. So there was a period of time that borrowers didn't know if they were going to be able to make their payroll. If you can restore those annual salary or average hourly wages by June 30th to the same level that existed February 15th, that will help reduce any potential wage reductions. In addition, if you're able to get your full-time equivalents back up to 1 by June 30th, that also will help with the any reductions as well. A couple things to note is that there were concerns that folks on unemployment are making more than if you bring them back, and maybe they don't want to come back. Maybe they don't feel safe coming back. If you had a written good faith offer to rehire that person that you laid off and they refused, that will not count against you. So it's important to make sure that those extensions to bring back the individuals are in writing so that you can document this. So that will not count against you. Also, if you fired employees during your covered period, you had individuals just voluntarily resign, and maybe you had individuals that requested a reduction in hours. Those types of things also will help be excluded from the full-time equivalent reductions. Now, John, I know if we want to advance to the next slide that we've gone over a lot of things. I didn't know if you wanted to add any additional things that you've been seeing in practice.
Yeah, Cheryl, I would. I think, you know, there are some open issues still. In the interim final rule, in a couple of them, they say that the total forgiven amount will include principal and interest. And I noted when I looked at the application, when it was released, the forgiveness application, suggested that the total amount forgiven is going to just be the principal amount. There was no mention of interest. So that's still hanging out there. You know, some other open questions that aren't necessarily directly tied to forgiveness, but folks are still wrestling with is, you know, they kind of follow along the same lines of the 401k match. You know, how else can you, as a borrower, as a business, as an employer, how else can you get push more qualified spend into that 8-week period? And, you know, I've gotten a lot of questions around that, anything from hazard pay to bonuses, to stipends, to advancing, you know, paying people for August and June, you know, all sorts of creative, shall we say, ideas. There is no guidance on this that directly addresses it. You know, however, we know that these costs under the certification have to be necessary to support ongoing business operations. So I think you've got to be prepared to answer that question. And, you know, my rule of thumb, the way I've been approaching it is that if the business is asked, why did you pay this expense in this 8-week period? And there's not a historic precedent for it. So i.e. it's outside of the ordinary course. If the business's answer is because I wanted to obtain PPP money and forgiveness, I think that is a sign that you need to be very careful with that. I could see the SBA and Treasury scrutinizing that very closely. You know, big bonuses to employees. I think that could be scrutinized. You know, I think things where you're able to generate and provide an answer that is business related and is not tied to the PPP are going to be more defensible. So, you know, I put this business or this bonus program in place, and it's actually going to extend beyond the 8-week period. And I'm doing it because I need to retain talent. I need to incentivize my people. I'm paying hazard pay because folks are still working and coming into close contact with customers, and I need to keep people. You know, I think those types of things are going to be more defensible than, well, I paid people in June for July because I wanted to take advantage of this program. I think those costs could be scrutinized more closely. The other considerations that are floating around out there are all of these pieces of proposed legislation. Cheryl and I have been emailing back and forth now in preparation for this presentation now for the last several days. And, you know, I don't know, Cheryl, I think I've seen at least 5 of these proposals now over the last week that would do any number of things. And what stuck out to me was the same thing that stuck out to you, which is that there seems to be coalescing some bipartisan support to amend the PPP to give borrowers additional time to spend their money. So, you know, going from 8 weeks to 12 weeks or 16 weeks or to July 31st, I've seen it a few different ways. That's been a very significant discussion that we've seen in Washington. I've also seen them talking about eliminating the requirement that 75% of the forgiven amount be spent on payroll costs, because that is locking out businesses that have like retail, that have a higher cost on rent and utilities than they might on payroll. So you've got that stuff floating around out there, which could be, a real game changer as to, whether this program makes sense for some businesses that may have sat on the sidelines.
Great. Thanks, John. So I think one of the things that we've mentioned here is there's going to need, with the loan application, there's going to be documentation. So as you're paying these expenses that are covered by the PPP, make sure you are saving that documentation so you're prepared when the application goes forward. John, why don't we advance to 2 slides? We did mention a couple times about, that if you're able to have the loan forgiveness, you don't have to pay that back. John mentioned clarification on whether interest is going to be forgiven, but the key thing is for any portion of that loan that is not forgivable, it is current guidance is it needs to be paid back within 2 years at an interest rate of only 1%, which is amazing. And the last couple points I wanted to finish up with before we open it up to some questions that have come in is probably the biggest one is the IRS Notice 2020-32, in which the IRS basically said that the guidance was clear that any cancellation of the loan forgiveness was not going to be income. But then the question was, with regard to all of those costs that were forgiven, those payroll costs and the rent and so on, is that going to be a tax deduction? And this notice said that the IRS has come down and said, no, you will not receive a deduction for these costs. Now, there's a lot of questions surrounding this because some folks are arguing that congressional intent was that to help businesses out, that these costs would be deductible. Some people argue that the IRS's logic might be a bit flawed as to what code section 265 that they're referencing. So this is an area of, we'll see if there's going to be some changes here. But right now, if you're trying to do projections for tax purposes for your clients for 2020, these expenses that are forgivable will not be deducted. However, the income is not includable in as well. So that's a good answer in terms of cancellation of debt is not income. We're hoping for a more favorable answer with these expenses being deductible, but right now the guidance is they will not be.
Yeah, Cheryl, a really crazy interpretation by the IRS, right? I mean, you've got Congress saying that the cancellation of the loan is not going to be income, pretty clearly trying to signal that this is supposed to avoid taxation. And then the IRS comes out with this opinion that says, yes, but if you spend the money on deductible amounts, and that's what businesses are going to do, you lose the deduction, which economically is going to put many companies almost back in the same place as if the loan had not been excluded from income. So yeah, that's generated a lot of buzz on the Hill, and there's been a lot of senators that have come out and proposed legislation to try to push this back. So we'll see where the bouncing ball lands, but that was a surprising one from the IRS. So do we have any questions, Mike?
Yeah, we have 5 here, and I'll try and briefly direct them, being respectful of everyone's time. The first question, I think, John, touches a little bit on some of the insight you just gave, which was, can back unpaid rent be forgiven if it was paid during the 8-week covered period?
So can rent so I assume what the question there is, can rent that was incurred prior to the 8-week period but paid during the 8-week period be forgiven? Yeah, I think one, to even have the discussion, the rent, the lease agreement had to be in place, as Cheryl said, on February 15. Whether this is going to be a permissible use is something for which there is no guidance on. What I've been assuming is that rent that's paid in the ordinary course, which is typically in arrears, is going to be okay to the extent it's paid within the period. But back rent that has been hanging there for a while, I don't know, because I've not seen any guidance. Certainly to the extent it's paid within the 8-week period, I think you're going to have a reasonable basis to take that position. But that's a bit of an open question. I don't know. Cheryl, did you want to add anything to that?
No, I agree with you. I mean, the language is interesting, how it's expenses paid and expenses incurred. As I mentioned before, the retirement benefits that accrued as of December 31st and paid, it looks like they could be deductible, but this whole area of the law has changed. Like you said, whoever checks, the SBA website on a daily basis to see what they popped up with additional questions, and the guidance, although the Treasury Secretary may think that everything is clear, as practitioners and business owners, it's not. The worst case scenario is you paid for it and then it's not forgivable.
Agreed.
The next question, Cheryl, was raised during your portion of the presentation, asking if you could define what was meant by transportation when you use that term.
I don't have a great understanding, even though I've looked around for costs that were associated with transportation at that point in time. John, did you have any more clarity?
The transportation with respect to which piece was that, Cheryl?
Utilities.
Oh, no, I have not seen any additional guidance that fleshes out transportation. What I have seen with respect to transportation is if the business owns or leases, if it leases a vehicle, that vehicle lease would be a bona fide expense under a rental, under the rental category. But under utilities for a vehicle, no, I haven't seen anything else beyond that.
Okay. The next question was, how would end of year rent escalation for increased utility costs for a landlord be handled?
Yeah, that's a great question. I don't know. And there is, kind of no guidance on how that's going to work. I think what I would be trying to do in those circumstances, and what I've tried to do in those circumstances, is look at kind of the historic precedent and try to forecast where we're going to be. And use that as some stand-in for the utilities, but you're going to need your documentation to back up your numbers there to show why you believe that cost was appropriate usage.
Okay. Next question was, is there a specific form to use to file a second application based on the guidance that permitted partnership income can be included in the loan computation?
I think what you need to do is you need to work with the bank that handled your first application. And you need to first figure out, to even see if you're in the game, there's a form, the number is escaping me right now, but there's an SBA form that the bank needs to file. It had been within 10 days of the loan being made, but that's now been extended. My understanding is that each bank approaches this a little differently, but if that form has already been filed by your bank, you are out of luck with getting additional funds related to the amounts you pay your partners. So first step, Mike, is to call your bank and figure out whether they filed this form with the SBA. If they have, you're out of the game. If they have not, and I believe they just extended here the deadline to file it through later this month, then you have a decision to make as to whether you want to take this money. I think one of the key considerations you should bear in mind, whether there's a certification that comes with this formally or not, is by taking more money now, you have to question whether you'll be held to the business circumstances that exist today as opposed to the business circumstances that existed a couple of months ago when you might have first applied. And for a lot of businesses, those circumstances are not as uncertain or dire. So I think it is a decision you want to make carefully, especially in view of the scrutiny that's being placed on these good faith certifications of necessity.
Thanks, John. Last two questions here. First is, are an employer's portion of FICA forgivable?
The employer's portion of FICA, there's guidance on this. It says it is not a payroll cost. Okay, so you can't use it to size your loan once that FAQ came out. And it is not a payroll cost, so it is not a permissible use of these PPP funds. You kind of get the flavor here that the government doesn't want you to use its money to pay it, right? So yeah, employer side FICA is out. Employee side FICA, all right, and employee side federal income tax withholding, those are in. You effectively use the gross wage number, but not the employer side Social Security or Medicare.
Thanks. And the final question was an example of how parking lot rent for monthly parking under an example of the Main Place Mall would apply under the course of the PPP.
Parking rent. So yeah, I mean, if you're leasing a parking space that is for business purposes, I would think you would be able to take that as a permissible lease expense. I haven't seen anything that specifically talked about leasing of a parking space, but so long as that lease was, so long as it is in fact a lease and it was in place February 15, I would think that there's a reasonable position to say that that's a permissible PPP expense and also forgivable.
Great. Well, I'd like to take a moment to thank John and Cheryl for their time today. I think it's been very informative and very helpful. Their contact information is on the screen if you'd like to follow up with them after the presentation on any other questions or any issues you may have that have arisen. Again, on behalf of the Loss Alumni Association and the Gold Group, I want to thank you all for attending and encourage you to check out the information on the law school website regarding the benefits of the Law Alumni Association. Consider joining, and keep a lookout for the May 28th presentation by Brian Detweiler at the law school and the June 12th COVID pandemic presentation on immigration matters. There will be other ones forthcoming that you'll get information about. Finally, again, want to thank our sponsors: AXA Advisors LLC, Chicago Title, Council Press, Fine Law, Jack W. Hunt and Associates, and Precision Resolution LLC, Paramount Settling Planning LLC. As the last reminder, I included in the chat box a link to the website where you can find the attorney verification form that needs to be submitted to Pat Warrington with today's code, loans, as well as a link to the program evaluation. If you would take a moment to fill that out, we'd really appreciate it. So thanks everyone, and hope you have a great long holiday weekend. Be well and be safe.
Thank you.
Thank you.